I am your host for today. My name is Roanne Lazarus, and I'm the underwriting head here at SHA in the Financial Alliance Department. I've been in the industry for a marvelous 16 years and occupied various roles in property, claims, as well as financial lines. Thank you, all of you, for joining today. We're thrilled to have participants, as I hear, across the entire globe, and we truly appreciate you taking the time to join us today. I want to start with a famous quote from Benjamin Franklin that said, "An ounce of prevention is worth a pound of cure." So, as we begin our fourth series of peril paralysis, we have carefully entitled this series, Can You Afford to Be Without D&O Cover? You have great front row seats today to navigate with us the various roles and witness our evolving landscape. We have an incredible panel, which I'll introduce in a second, who will share their journey and experiences. We hope to leave you with practical takeaways and a fresh outlook and perspective on our ever-changing field. We South Africans celebrated Heritage Day yesterday, so I hope you all had a wonderful time reflecting on our rich cultural diversity and enjoyed some quality time with friends and family. Hopefully squeezed a braai or two as well. So let me introduce you to the panel. Here we have Pierre Lombard. He's a technical manager in the casualty claims team with specific focus on financial lines, and his particular interest in D&O claims. He has nearly a decade of claims handling experience and has been part of precedent-setting matters relating to directors' rights and duties, including Supreme Court of Appeal judgments. Pierre is passionate about assisting directors during the turbulent times when they are subject to these legal proceedings. So a real core passion, Pierre. Colin Wiseman, he started his career in 2008 and has over 6 years of forensic investigation and litigation support experience. He started with us at SHA in 2015 and currently occupies a position of technical manager in FL, PI, and liability claims with a focus on D&O and crime and civil liability claims. We are very honored to have Donnie Leroux. He is a partner at Clyde & Co., and he's in practice since 1983. Donnie's practice focuses on liability and coverage disputes, and he's recognized as a leading expert in dispute resolution and insurance law. He has extensive experience in casualty and the property sector. Donnie is highly recognized in the industry for his work and insurance and dispute resolution. So thank you to our panel for taking the time to share your insights and learnings and experiences, and I know that we're all in for a good treat. I'd like to just turn our screens to Menti. I'm sure a lot of you know how to use this platform. On your screen, on your phone, you'll see a QR code, or go to www.menti.com and enter the code that you see on your screen. We have some questions that we'd like to pose throughout the session, and just to get to know you a little bit in a few seconds. So let me just see if everybody is, we'll give you a few seconds to log on. So the first question will pop up on your screen now. Where in the globe are you listening from? Okay, I think we're going to pose that question again. So I think that's an open-ended question. Those things shouldn't be at the bottom. Okay, let's go on to the second question. Which industry and capacity, or which industry are you from, and which capacity do you hold? Insurance relationship manager. We have a key individual. Okay, we'll be speaking to you quite a lot today. Okay, there seems to be a little bit of a delay, but can we then go into our next question? What are your expectations for today? Okay, I think we're having a little bit of a technical issue on the mentee. Let's just dive in. Today we're going to focus on perils that are facing directors of private companies, including some regulatory risks and statutory liability, and why should no director be without this cover at any time. So during our underwriting process, we get a lot of questions relating to the D&O policy, specifically as to why is this policy actually necessary? How does it assist our directors? And there's a lot of confusion as to what the benefits of this policy would have on the company, on the directors, because it's actually the company that's taking this policy on behalf of the directors. So these questions usually come most frequently from the medium to small business and who feel that they run a relatively small organizations with limited shareholders. They aren't really public listed entities and therefore feel that they're not subject to the same regulatory environment as the public listed entities. And as many directors feel that, well, they act merely on behalf of a company, and the risk of litigation are really aimed at the entity and not themselves. So therefore, the cover seems very unnecessary. Which leads us to a very important question, which many directors don't necessarily contemplate, which is, what are the actual risks that the directors face today? And is this cover necessary? What regulations, what rules, and that are obviously subject to a director? And we felt that the easiest way to sort of explain this is through way of an example. So, for example, if you are a newly appointed director for a medium-sized business, an operations manager, a finance manager, a director, the business isn't, and the business that you run isn't a listed entity. There are only a few shareholders. Most of them are, in fact, all of them should be directors as well. And the question you need to ask yourself now is, now that you've been newly appointed in this role, what extra responsibilities does this position require of you? And where do I find these responsibilities? So the starting point for any director is to look and to gaze onto the Companies Act. Every director who takes on that responsibility must understand the nature and the role and the capacity in which they currently hold. And I think most importantly, they must understand what a director requires of them. I know that the rules might be very long, but they need to understand it. So this brings me to, does it mean, so we get this question a lot of the time is, does this mean that you as a director are required to know and control every single aspect of the company? And the Companies Act actually gives us some foundational principles, and the central requirement that is a theme throughout it is that directors, there is a fiduciary duty towards the company. Okay, and the Companies Act also provides that the director is obviously able to rely on the employees of the company, in terms of the reports, in terms of reliability, in terms of competence, in terms of the opinions and statements that they might help the director to make the decisions. And the Companies Act basically sets out those duties and responsibilities. Before I go, I'm going to try the mentee question again and just see if what is the source of a director's duties. Let me just see if that's up for us today. We'd really like to see what your responses are in terms of the source of a director's duties and where can we find them. Do we have the responses? Not yet. Okay. All right, so let's pause to just point and ask our panel, probably starting with you, Colin, and to just flesh out, are all directors' responsibilities and risk found within the Companies Act?
Thanks, Ryan, for that question. So there's a lot of duties that directors have, and they're not all exclusively in the Companies Act. There's a whole world of regulatory compliance that directors need to be aware of, which can have consequences of being held personally liable if you're in breach of those regulatory rules and regulations. There's also a rich history of case law and precedent that's been set, specifically on the fiduciary duties of a director and looking after the best interest of a company while they are performing that role, and putting their duties ahead of the company when they're performing that role. And part of the discussion that we're going to look at today is those risks that fall outside of the Companies Act, which directors need to be aware of. And those risks are often things that directors didn't anticipate or contemplate in the running of the business that they might be held liable for.
Yeah. And just in terms of, can you just touch on some of the, we've mentioned before that I think directors don't feel that they would be faced with any litigation because it's the company that's taking out this policy for them, and that they feel that any litigation would be against the entity and not themselves. Can you just highlight on that?
Absolutely, it's a foundational principle in our law that there's the corporate veil, and directors often think that that's a shield that protects them completely, that their actions are on behalf of the company and that they're not liable for those actions, which is, in most cases, we would like to think that is correct. And our law, and we'll speak about this later on in our show today, there is that protection for directors, but there are certain specific instances, especially involving negligence and fraud, where directors can find themselves in a position where the corporate veil is being pierced, where they are being held personally liable for acts that they have committed that have perhaps caused loss to the company itself, or to creditors, shareholders. There's a whole bunch of different regulatory rules in place that we'll go into greater detail and have a look at today.
Perfect. So, I'd like to go. We specifically sort of centered this for private companies because I think the question that as underwriters we also face is that, well, we know the JSE listed companies and we know what happens because it's all sort of blasted onto social media. But the private companies, are dealt with a little bit differently. And people don't see that there's a risk and exposure also. So I'd like to just go a little bit deeper into the regulators' powers, investigations, findings, and the sanctions more specifically. So let's start with the Companies Commission, the CIPC. Here. Why is it important that we operate within this legal framework? And why is it important that a director needs to understand this? And what are the implications if they don't?
Yes, thanks, Roanne. So the role of the Companies and Intellectual Property Commission, the CIPC, is to administer the Companies Act. And so the goal of this regulator is to keep records and make sure that the rules of the Companies Act are complied with, and the Intellectual Property Commission. But for purposes of D&O cover, these are the major risks. So the CIPC has extensive powers to investigate complaints, or if they suspect some breaches of the Companies Act, they can do so out of their own initiative as well.
And where does this complaints come from? Who can complain?
Well, anyone that is affected by breaches of the Companies Act. Okay. So let's take as an example, if there's a complaint that a company is traded recklessly or in insolvent circumstances. So firstly, that would be a breach in terms of the Companies Act. And there's also a criminal offense for directors to act in those circumstances. And then the CIPC can investigate if that is in fact the case, and if if they find that the company is trading in insolvent circumstances, they could issue a compliance notice to show cause why the company should be permitted to continue trade. And if they don't do so within 20 days or don't show sufficient cause, the CIPC can issue a compliance notice to the company to cease trading, which has severe consequences for the company. And they can at the same time refer it to other regulators, including the National Prosecuting Authority, if they traded recklessly, because that is a criminal offence, and the directors could then face criminal prosecution.
So let's go on to another topic, which is, they say that the only two guarantees in life is death and taxes, right? So let's just go into, is it true that SARS can sue the directors now personally for unpaid company taxes?
Yes, certainly. That is, look, SARS is a very technical organization. They have a wide variety of powers and different acts and legislation that authorize them to take certain steps where necessary. When it comes to companies in particular, there is always the duty for the companies to pay tax. And it's important to note that obviously the company is the one that needs to be paying the tax in most situations. However, there's the CIT, which is the Corporate Income Tax Act. There's the VAT Act, and there's also the Custom Duties Act and PAYE legislation. There's a lot of different legislation in place. And when you get to a situation where the Revenue Service believes that there has been negligent or fraud on behalf of the directors in filing their tax returns, they are empowered in terms of the legislation to do an investigation and to potentially hold the directors personally liable for the outstanding tax. Now, obviously, this goes into the piercing of the corporate veil. They don't do this lightly. It's only in situations where they believe that there is an investigation or there is tax fraud, or that the directors are using the corporate entity as a vehicle to manipulate or to avoid tax. So in those situations, if there is compelling evidence that they believe that the directors are using the corporate entity to evade tax, they are empowered by the legislation to do an investigation. And this investigation, it's not automatically deemed that the directors are liable in their personal capacity. However, it could result in a very broad investigation calling all directors to account, and then by way of evidence and the facts presented to the courts, they would be able to determine which directors are personally involved in submitting the taxes, because not all directors have the skill set and the abilities to do the financial returns and to submit all the tax returns. So it becomes an investigation, inquiry type process. In a formal court proceeding, all directors can be called up, all directors are given evidence, and through this process you can establish if there is a director that is acting negligently or fraudulently, trying to use the company to hide and avoid the taxes. They can then be held liable in their personal capacity. So it's very damning legislation if there is these penalties, because not only can they be liable for the tax that's outstanding by the company, but there's also penalties that can be brought against the company and the directors. It could result in other actions being brought by creditors or shareholders who have been impacted by the tax situation that affects the company negatively. So it's a very important legislation that people need to be aware of, and they need to make sure that if they are not qualified to be submitting the tax returns, that they have the necessary experts to be making those tax returns to assist them in that process to avoid being held personally liable.
Can I add something to that? I think an additional consequence for directors, you mentioned fraud or misconduct in the context of tax. The CIPC can also refer that type of conduct to a court to have the director declared delinquent. So that would be in instances of like fraud or misconduct, or if they act in bad faith or in conflict of the interest of the company. Even if a director is found liable criminally in separate proceedings for dishonesty-related offences, they can also be disqualified by a court.
Yeah, and I think it goes without saying that. I mean, defense costs are expensive, and you know, even if you feel and believe that you haven't done anything wrong, you still need to advance. You still need to pay those defense costs. You still need a good, reputable insurer. The one that's on your screen is, you know, to really, really back you up, especially when it comes to these very sensitive matters.
Well,
Can I jump in,
Yeah,
if
sure.
I may?
Yes.
It would be so wrong to think that these things don't happen in real life, because I was saying earlier on, we actually dealing at the moment with a claim where a receiver in another country, admittedly, has given notice to 2 directors calling upon them to pay the company's unpaid taxes. And the basis of the liability is that they were in charge at the time in the management of the company's finances and did not allocate cash flow, income, to the paying of taxes. They diverted the income to doing other things. So there are defenses that are open to the directors, as Collins mentioned, but it doesn't mean that this is a rarity. It really happens, and you need to know about that risk and have in place a policy that will protect you against the cost that you'll have to incur in having set aside the directive by the receiver.
Exactly, and I think we don't mention it, like I said before, is that we only look at the publicly listed ones that are just marred against, you know, the social media, but it's the private entities that are also going through these things that are not so publicly noticed. But as you said, I mean, it's quite a reality.
Let me just debunk that misconception. There is very little difference between the liabilities of directors of private companies and listed companies. So the Companies Act is quite specific about that. The duties are the same.
Yeah.
And I think additionally, we often think about listed entities as having more resources than private companies would, especially the directors aren't necessarily as well paid in private companies. So the defense goes against their personal assets. And it's, as you mentioned, very expensive to defend against these cases. So you don't want your private dwelling to come up for auction to pay your legal defenses.
Yeah, or that yacht that we were saving for. So the Competition Commission was obviously established to promote and maintain, you know, fair competition in the economy, and the main purpose is to prevent anti-competitive behavior, price fixing, cartels, those kind of things. And we've seen quite a lot of mergers, acquisitions, quite of activity happening in the market recently. And can I pose this to you, Pierre? Is from a Competition Commission perspective, you know, how does the director stand in that sort of legal framework, and what do they need to do?
I found an interesting element in the Competition Commission legislation, and that is entities that are in horizontal competition, so they call it restrictive horizontal practices are prohibited. So that's basically entities that compete with each other on a similar level may not reach an agreement to divide markets or fix prices or something to that effect. And an interesting element is that the entity, or there's a rebuttable presumption in the Act that says if there's a common director between 2 entities that compete against one another, or if there's a significant shareholder that is common between 2 companies, there's presumed to be an agreement to restrict competition, and the onus moves to the company to disprove that they're not in this type of a relationship. And So in that context, it's also important to note the wide investigation powers of the Competition Commission. So they may, for instance, we've all heard of these dawn raids, but if you dig into the legislation, it's quite. They may do some things that one would consider to be almost unfair. As an example, that when executing a warrant in terms of one of these dawn raids, they could access the computers and seize all of the output of that computer. They may even ask someone on the premises to assist them in accessing specific records in that computer, like an accounting system. And they may seize that, so it may be difficult for the company to then continue with its business if it doesn't have access to that accounting system.
So,
Interesting.
Pierre, on that note, so you're saying not only do they have the power to enter your premises without notice, seize all your information, computers, documents, as well as there being a reverse onus. So the onus is on you as the directors or the company to prove that you weren't embarking on horizontal practices.
So the investigation powers, the investigation could go as wide to determine if there was one of these agreements to prevent competition. So I guess in that context, yes.
Yeah, so it's quite a strict,
Yeah.
definitely
Danny,
something
do
to be
you
aware
have
of.
any comments around that?
I'm fortunately not a competition lawyer, so but they're quite right. I mean, the commission investigates and have draconian powers in conducting an investigation. Of course, the material is then put before the tribunal, who, of course, will decide. But it's by the time you get to the tribunal, you would have been put through the ringer.
Yeah.
It is very, very onerous, unbelievably taxing on those who are involved. And as I said, the powers are quite draconian.
So it's interesting you mentioned that it's referred by the Competition Commission to the tribunal to decide on whether this conduct occurred. But if the commission decides not to pursue it further, the complainant may refer it to the tribunal, of course, at their own costs and risk. If it's unsuccessful, they have to pay the cost. But if there's someone that... So it's outside of the protection that you would expect from a regulatory entity if a external party can drive that process. So
Yeah,
it's a risk
definitely.
for directors.
So that comes to one of a hot topic, which is the information regulator, which is POPIA, and we see that POPIA says that it really spills out as to the responsible party, and it really outlines who that responsible party is, and I'm sure you're going to go through that in taking reasonable steps to ensure that how you process any information, how we access it, what information is going to be out there, and this is quite an onerous sort of responsibility given. Have you seen, what has been your experience with that?
So the Act sets out the conditions for lawful processing of personal information, but it also determines the standards. So, for example, if you take the security safeguards, which is one of the conditions for the lawful processing, the information officer needs to be registered with the regulator before they may implement certain acts. But once they are, then they need to identify risks to personal information under their control, and implement solutions to protect against those risks. And they must keep it updated and make sure that it's implemented correctly. So you would have seen in like in the SARS scenario, a personal tax number is registered against the company, so someone is always responsible. So it's a similar type of regulatory protection that there's a person that is nominated, and the regulator knows specifically who that is, to go and knock on their door if there's non-compliance with the regulations.
Okay, so there's that where the civil claim also might be brought against by the regulator, and obviously some hefty fines, up to 10 million rand, or criminal prosecution. So quite a serious penalty.
Yes, so the regulator has, they can act in various ways. So they, in the one instance, they can bring a civil action against the company. So not the data subject that was affected by it, although they also have a claim. But if they give consent, the regulator can enforce that claim on behalf of the data subject if there is a breach of their data. And the Act also, there's an argument to be made that the responsible party may be strictly liable. So even if there's no negligence or intent, they can be held liable for damages to the data subject. And they can also claim aggravated damages and non-patrimonial loss. So even like the psychological consequences can be claimed against the company, and if there's a specific breach by the director, against the director as well.
Yeah, so we see a lot of focus also in directors being faced criminally also. And we go, if we can go to you first, Colin, and then Donnie, into the National Environmental Management Act. And there are some serious, sanctions and penalties that, and quite serious outlines as to the do's and the don'ts. And that really sparks a lot of interest, because you can be faced criminally for breaching these.
Yeah. So the NEMA, that they call it, the National Environmental Management Act. So it's quite an interesting setup, because all the breaches, all the conditions of pollution are set in a schedule, and it links up many different acts that are all related and fall under the NEMA provisions. And it's quite onerous. In the NEMA Act, it says specifically, if there is a company or a corporate entity that is responsible and has caused the pollution, not only is the company liable, but the directors of that company are jointly and severally liable, and it's also a criminal offense to breach any of the legislative rules on the National Environmental Act. So the way that the Act is set up is there's three different variations. So either the company is responsible for a pollution breach, and the company and the directors are held jointly and severally liable. The next point you have is where your employees have committed the pollution, intentionally or unintentionally, it doesn't matter, then that puts the responsibility on the company. So that brings in your vicarious liability into them. Then you have, if the directors were responsible and should have foreseen that the actions would have caused the pollution, the directors can be held personally liable. And all the offences in terms of the National Environmental Act is criminal sanctions, criminal fines that can be involved, as well as if they have been found guilty in terms of the acts in the criminal proceedings, at the moment of judgment, the courts can then call for the costs and find out what costs have been involved in restoring the pollution that has been caused as a result of this incident. And that can also be put onto the director or the company in their personal capacity. So it's quite an onerous legislation that everyone needs to be aware of. And some of the reasons why you need to be aware of, because the Act is so wide with Schedule 3, it includes stuff like veld fires, the acts that govern the farmers, and veld fire damage, as well as water pollution, air pollution, spillage that's taken place, nature conservation, animals as well, if there's there's a whole host, and if you go look at Schedule 3 of the Act, you'll see it's quite a long list of different, not only national legislation, but also provincial legislation that all falls under this Act. So it's very onerous. If you are near a waterway, if there's chance that you could pollute the waterway, if you're transporting goods that are hazardous, there's many, many areas of risk where you could be held liable for this.
It is quite wide.
I think it's going to become a hot topic in the future. I think with the environment being so important to all of us, I suspect that you will be seeing a lot more actions and claims arising out of the liability provisions of NEMA. I just want to make the point again, Colin mentioned that the directors are jointly and severally liable, and it's irrespective of negligence. It's a strict liability. They are liable for their negligence or for intentional conduct, but it's a strict liability. And that is what is the scary part of it. Because it's not only a civil liability if someone wants to claim damages, but it would certainly give rise to criminal prosecution as well, and that's the scary part.
And also the reverse onus that seems to be implied there. So the state only needs to prove that there was an event that caused pollution, and that's prima facie evidence that they are in breach of the Act. So that means that the onus is on you to prove that you are innocent from the charges. So it's quite a steep situation to get out if you do have that, if you are charged with those allegations.
If the company that caused the pollution does not clean up the pollution, then the state has the right to go and appoint somebody to clean up the pollution and then recover the costs from the company. So this is really serious stuff.
Yeah, and all the other sanctions that obviously goes with it, fines and penalties and all of that nice little things that we don't like to hear about.
Definitely something to be aware of.
Yeah, definitely. So we'll move to to what is really in our world very important, which is the Financial Services Conduct Authority, the FSCA, and this is in South Africa. It oversees several acts in promoting the financial sector, integrity, and protecting customers, obviously. And Pierre, can you really touch on this act? Is it applicable to, and the penalties for the non-compliance? Because I'm sure everybody on this call has to deal with the FSCA in some way.
Yes, indeed. And so I think from the perspective of the enforcement actions that the FSCA can take, is similar to the other regulators that we've mentioned. The investigation powers are very wide. So a peculiar power under this act is that a regulator can compel someone that they are investigating to provide self-incriminating testimony, even though they are aware of it, with the only protection being that they may not be, that evidence may not be used in criminal prosecution. But they can still impose fines and so follow the lead from there and go and find further evidence to bolster their case. The FSCA can also regulate the industry by issuing and withdrawing licenses and issuing compliance notices. So as you mentioned, the penalties, they can impose fines of up to 10% of the turnover of a company. And in instances like insider trading, which is more applicable to listed entities, but in those instances they can impose unlimited fines on directors personally. They can also, similar to the information regulator, they can pursue reparations for damages on behalf of complainants that suffered a loss. I'm sure you may have some examples on your side, Donnie.
Sadly, yes.
But I'd also like to just mention before is that there are also private entities exercising public functions that we need to also think about that can also be handed over to the FSCA for enforcement. And that's quite interesting because we always just think it's public and there's such like a dividing line. And as you mentioned, Donnie, the regulations and the duties are not that different from each of those companies. So we need to be a little bit more zoned in into realizing that the duties as a director are very much the same in a public entity. Yes, there is more regulations in that public entity, but just as much there is in the private sector as well. Over to you, Daphne.
Yeah, there are several reported judgments dealing with the investigative process carried out by the FSCA's investigation division, and they are really, really draconian. I must say that when I read some of the judgments again in preparation for this talk, it actually sent some cold shivers down my spine because it is really up to the investigators to ask, or they can ask any questions, and you have to answer. Whether that evidence ultimately is accepted and the case is made out, that's for the tribunal to decide when it gets to that part. But it doesn't stop them from asking questions and making recommendations based on the answers given to the tribunal. So, again, these are serious powers, and if you are a director and you are subjected to an investigation and an inquiry by the FSCA's investigation division, you will really need legal representation. You may need lawyers all the time. You'll be well advised to do so. So you need that protection under the D&O policies, pay for legal representation costs.
Yeah, definitely. So I think that's also. Can you also touch on the Commission of Inquiry, just on I think other than good governance, it's very little the director can do to anticipate it or sort of prevent these things, and I guess that is why it's very important, like you said, to have a good D&O policy with a good substantial limit to sort of help you through those difficult times.
Of course, inquiries can arise under several statutes, like under the Mines Health and Safety Act, for example. And the one that most of you may know of in that context would have been the Marikana inquiry. And that ran for a very long time, and you can imagine what it must have cost to attend the inquiry and pay for lawyers to be there and argue your case and so on. You take the Zondo Commission. I mean, who would have thought that the commission would sit for, I think, something like 2 years?
Yes,
so these things happen. They are things in real life in our time, and they serve as rude awakenings for people who think this can't happen to them.
Absolutely.
Yeah, the regulatory also, because it's a trial of giving evidence. It's not a formal trial in a court, but it takes a lot of time. It requires you to produce documents and records. It requires you to be there, sitting every day, giving evidence. And that racks up the costs, not only personally because you're now out of the office and you're in these regulatory hearings. You need representation. You need to get advice of the evidence that you're giving, because you don't want to give evidence that potentially incriminates you or other people or has consequences that you didn't think of. So yes, these inquiry hearings need guidance and assistance, and that's why the policy is in place as well, to assist when you do find yourself in these situations. Specifically the defense costs. Yeah,
and I think just outside of the the psychological effects also of a director that he has to go through all of this time and time again is quite taxing as well, And civil actions against directors, how do they manage this, Pierre? I think I'll pose this to you and Donnie, but I think there's additional issues from a regulatory aspect that we don't that doesn't receive the main focus. And I think, Donnie, I know that you have a case law that you'd like to share with us, if you can.
Sure. I think that all directors in the country owe a debt of gratitude to SHA because they instructed and defended us, or instructed us to defend directors of the African Bank. And that case went all the way to the Supreme Court of Appeal. And the question was whether shareholders who suffered losses as a result of the drop in the share price after the entity has sort of either gone insolvent or has done something that caused the share price to drop. And the question was whether shareholders could hold the directors directly liable for the losses that they suffered as a result of the drop in the value of their shares. And the court found that directors owe their duties to the company, and that it is the company that must recover the losses from the directors, and by restoring to the company the loss that the company suffered, therefore, by extension, the shareholders. Will recover the value that they lost. That's the sort of theory behind it. But, I mean, there are at least 3 leading cases on this topic, and all of them affirm that principle, that directors are not liable to shareholders. There are exceptions, of course, like always in law, but they owe their principal duties to the company, and it is the company that recovers from the directors.
Absolutely.
I think there's some more good news on that front, in that the Companies Act also makes provision that directors, which we all expect take a measure of risk when they run companies, that there is a fair measure of leniency afforded, and a court can even, they call it the business judgment rule, but where it's fair in the circumstances, even if the court finds that the director is probably liable, if they acted in good faith and in the best interest of the company, the court can still excuse them. So there is some good news. If you act reasonably and fairly, the court will excuse you.
Looking at the reasonable director, I guess. Yeah, that's always subjective or
Always.
objective.
And always comes back to your fiduciary duties. Are you acting in the best interests of the company?
Yeah.
With due diligence. You know, if you can say that that is how you are acting all the time, that's always a great protection from these kind of situations that you may find yourself in. And relying on the experts where you don't have the expertise to figure out these complex matters. Use experts, accountants, attorneys, other expertise and professionals to assist you to make sure that you are acting in the best interests of your company.
100%.
Look, even if you do all of that, you still can't stop anyone from making a claim. And that's where a DNO policy comes to assist, because it costs a lot of money to defend against these types of claims. If you allow me a moment, I'd like to just give an example of where all of these types of risks meet in one specific example that I dealt with a number of years ago. It was a privately held short-term insurer that came into some financial difficulties, and as a result of that, the FSCA, or as it was then known, the FSB, had a fair measure of oversight over them and had specific conditions for their continued trading. They had to raise additional capital and meet certain solvency ratios. And at some point, they just couldn't meet those conditions, and the FSB then suspended trade, but also applied for the company to be liquidated. So that then led to investigation by the FSB under similar rules and investigation powers to as they would have under the FSCA. And they asked the directors to provide evidence, and they required legal representation during those investigations. And they were also subject to civil actions by the reinsurers. So the particularities of that specific case was the reinsurers said that they had to keep the premium deposits and certain claim deposits separate from their own funds, and they didn't do that, and because of that it was subject to the liquidation proceedings. So the reinsurers said that they suffered a loss, but they also alleged that the directors are personally liable for that because they traded recklessly and under insolvent circumstances. That was quite the high onus, and the evidence didn't quite support that. So after a few years of very expensive litigation, the claimants then offered to settle for a contribution towards their costs, which even though the directors had defenses, it didn't make sense to pay additional costs for the defense. Even if they were successful, there are always some costs that you can't recover from the claimant. And in this instance, we represented the directors under a D&O policy, or at least indemnified them for the costs that they incurred for the legal representation. And in total, for the regulatory and the civil proceedings, it cost 7.3 million rand, which I doubt, given the long history of financial difficulties, that the directors would have been well enough compensated to carry those costs themselves. So, the D&O policy is definitely necessary.
And what period of time, more or less, Pierre, did that matter run?
So interestingly, the investigation by the regulator has still not come to a conclusion, and it's been 7 years. So there's still potential to continue.
And I think just to remember that your limit of indemnity is so important. You just can't look at your revenue and your assets like a normal assets policy and say, well, I'll be insured for this, and 500,000 or R1 million is actually sufficient. It's really not, as we've seen, these cases and time and all of these things can rack up your cost quite significantly.
So your risk is costs.
Your risk is on advancing defense cost, and that is one of the forefront or the forerunners of the D&O policy. And then, we've been talking, sorry,
I just want to add, the problem is that you're not in control of the timetable.
Right.
The timetable is dictated by the investigations, by when is the tribunal available, when can you get a trial date, and all those sort of things dictate the pace at which these things happen. And the time, of course, is where it takes a lot of money to keep preparing, be ready, etc., for all of these investigations.
Yeah, and I mean, you could have been retired 10 years, and now things are coming up. So, if I was a director, I would want to ensure that even if I'm retired and I'm buggered off to some other place, I want to ensure that my policy is intact.
Especially if you're retired, because there's long tail in a lot of these cases. Can see you well into retirement. Exactly.
I still want to keep that yacht, Colin. Let's look at non-executive directors. We've been asked quite a lot. We get directors phoning or brokers phoning and saying, "Is a non-directive? Am I covered? What? Are they actually held in the same sort of views as a normal director?" And maybe I'll pose this to you, Donnie. Is what are the sort of duties? Are they the same as a non-executive director as a normal director?
No, the Act itself does not draw a distinction between executive directors and non-executive directors.
Yeah.
So they are directors for purposes of the Act, and where the Act imposes liability, it imposes liability notwithstanding whether it's one or the other. But it is in the consideration of whether the conduct was such that that particular non-executive director should be held liable. Of course, that's where there are differences between executive directors and non-executive directors, because executives are hands-on running the company, whereas the non-execs, of course, are not. So it is in weighing what they knew and should have known and done and should not have done that it's more difficult to hold a non-executive director liable than an executive director. But believe me, it happens.
And
Yeah.
this will play out during the trial process.
Oh, yeah.
So that's not saying that you're going to avoid being summoned. You're going to avoid being named as a defendant in the litigation if there is litigation for the breaches, and that you're going to avoid court because you're going to be in court taking the stand and giving evidence. It's only once the evidence has been presented, once the whole court case is played out, will you determine, and the court will determine that, okay, that non-executive director didn't have a hand in these alleged allegations against them. But you still incurred the costs and spent a lot of time in court getting to that point.
Absolutely. So we are at our end for the first segment of our series. We are going to take a 5-minute intermission, and then we are in for another treat, which is Donnie, and he's going to really speak about some interesting topics, joint and several liability, that we get asked all the time about. It wasn't me, how do I do this, and what the actual meaning is. So we are just going to have a 10-minute intermission, and we will see you. You can just stretch your legs a little bit, and then we will see you just now. Okay, question 1 comes up now. Where in the globe are you listening from? Wow, that's lovely. So we've got quite a variety. Cape Town, Pretoria, Mauritius. Our local is Lekker. Wonderful. Question 2. Let's move on. Which industry and capacity are you from? What industry, and then what capacity do you hold? Okay, we still have key individuals, so they're still here, ready to listen.
Any directors out there?
Any directors? I think they're not going to say, hey. Wonderful. A lot of brokers, loss adjusters, key individuals, account executives, financial advisors.
No.
Underwriters. Great. Next question. So we wanted to ask this question earlier, but I think there was a glitch. What is the source of a director's duties? Okay, at least we do have none of the above. I was just going to say we don't have none of the above. Yeah, so yes, the correct answer is all of the above. So your duties are centered in all of these pieces of legislation. And then we have the next question. How long does a regulatory investigation last? Yeah. Years and years and years. I think Colin made a comment, how long is a string?
Yeah, how long is a piece of string? Because that's how long they last.
Yeah, forever. So it does take a lot of time. I think, Donnie, what is the, like just in a court case or, just going to court, what is the trial dates now? How many years? Oh.
Yeah. You will probably now wait about 2 years to get a trial date. So it's a long time.
Yeah.
And the scary part about the waiting period, of course, is there is a very ugly thing called the Prescribed Rate of Interest Act. And it provides that interest will run on a debt from the date of the demand or from the date of the issuing of a summons. And the current interest rate is 11.75%. It's the best investment you can make as a plaintiff. So, the longer you wait for that trial to get going and get a trial date and for the hearing to start, you constantly at risk that interest is running in that time. So it's a serious issue that people often lose sight of.
We don't take that into consideration, hey? Okay, our next question. So the correct answer is definitely, it can last for years. Okay, I think we touched on this because there's so many, everybody's yes, before I even read the question, but can the non-executive directors be held liable on the same basis as an executive director? Pierre, do you want to answer this one?
Donnie,
Donnie. Okay, let's go to Donnie. I think we did touch on it, but I'd really like your...
Sure. The Companies Act draws no distinction between executive directors and non-executive directors.
Yeah.
Where it becomes important is when it is to be determined whether a specific director has been liable to the company for losses suffered. In other words, where the director breached his duties, is there a distinction then to be drawn between the duties of an executive director or a non-executive director? And I think the answer to that is yes, there is a distinction at that level, because the non-executive director is not involved in the affairs of the company on a day-to-day basis.
Correct, yeah.
I must just sound a word of caution. Even a non-executive director who involves himself practically in the day-to-day running of the company is then putting himself in a different position. So, these things all have nuances. Take, for example, the chairman of the board or the CEO. Are they to be judged on a different basis than other directors by virtue of the office that they hold?
Yeah.
So typically in law, the answers aren't always sort of straightforward. There are shades of duties by virtue of the position that is being held. So, non-executive directors can be held liable, but there is a nuanced difference when it comes to determining whether or not they breach their duties.
Correct. Thank you. So we are going to get into our next segment. There will be a presentation up, and we're very, very lucky to have Donnie really go through his insights and learnings with us. We have a few questions on the chat, and we'll try and answer them as well after the presentation. Over to you, Donnie.
Thanks very much. I've been given a few topics to talk about, so if we go through them quicker than anticipated, then there's some backup material. But I'm sure with Pierre and Colin, we can fill in the time. Before you get to joint and several liability, it's perhaps good to just pause a moment to talk about liability and the structure of the board and how things fit together, because there's a scheme in the Act when it comes to the liability of directors. And the Act is intended to codify the liability of directors historically at common law and so on. So the starting point is, of course, to determine who is a director. And is the director from the time that he is appointed and he has accepted that appointment. Now, Section 66 is a section that's rarely mentioned when you talk about liabilities, but it's a very important section of the Companies Act because it deals with the functioning of the company. It provides that the company acts through the board of directors. So the board of directors is responsible for the day-to-day functioning of the company in accordance with its memorandum of incorporation and subject generally to the Act. So the building blocks of the joint and several liability that follows later on, you've got to go back to see, well, what's the structure that gets you to that joint and several liability. There are certain sections in the Act that creates joint and several liability, and then there is joint and several liability that's specifically addressed in Section 77, to which I'll get in a moment. But the important point is that the board is the entity through which a company performs and carries on business and so on. And therefore, that's where the duties of directors become so important. The standards that a director must meet under the Companies Act and at common law are set out in Section 76 of the Companies Act. And they are critically important to the way in which a director will be, a director's conduct will be measured. Because ultimately, to try and put it in a nutshell, the company director is required to act in good faith and for a proper purpose, in the best interest of the company, and with the degree of skill, care, and diligence that may reasonably be expected of someone in his position and with his general knowledge. Yes, a director is not supposed to know everything, but he's expected to be informed of the topic that is to be discussed or on which decisions are to be taken. He is entitled to rely in the discharge of his duties on the work done by others, employees of the companies, committees of the board, professionals employed for that purpose. So the director will be deemed to have complied and discharged these duties if, for example, he has relied upon the advice of professionals on a particular topic.
That he still holds that fiduciary duty.
But he still has the fiduciary duty.
To the company, yeah.
And it is, he's judged, I think quite fairly, he's judged with reference to a person of his experience and knowledge. So that, I think, puts the bar at a reasonable sort of level. But the importance is that there is a section of which you must know as directors, and it is 76, and it sets out in detail what the obligations are of a director when it comes to functioning and performing as a director appointed in terms of Section 66. And then there is the very important Section 77, which is the section of the Companies Act that deals with the liability of directors. And what is important about that section is that it makes it quite plain that a director owes his duties to the company. Director does not owe duties to shareholders. There are certain exceptions, but as a general statement, directors owe their duties to the company, and it is the company that will then sue the director for the losses suffered by the company if the director breached those duties that are set out in Section 76 that I spoke about earlier on. So before you can get to joint and several liability, you first got to get a director liable for breaches of his fiduciary duties and other failures that arise as a result of breaches of the duties under 76. But once he is held liable, then any other director who's also liable for the same breaches is then jointly and severally liable. And the fact that a company director, that one company director is sued, does not mean that the company director that is then sued cannot recover from another company director that was equally to blame. And that is specifically embedded in Section 77(6), the right to join somebody jointly and severally in an action for damages, for example. But the joint and several liability does not only arise under the Companies Act. As we said before the break, the joint and several liability can arise under other statutes as well. So don't think that joint and several liability is only to be seen in the context of Section 77. It goes much wider than that.
So, Donnie, would that play out in court with the one director named? Would he then include the other directors, or do you generally find that the plaintiff will sue all the directors equally?
I think as a general statement, you will probably find that the plaintiff will sue all of the directors.
Okay.
Now, suing all of the directors, of course, is a bit of a nightmare for the insurer, because each of the directors would be entitled to own representation. We always try and manage that position because you want to avoid infighting between the directors as much as possible as a strategy, because in doing so, you're making the case for the plaintiffs. So it's really difficult to deal with D&O claims where all 12 of the directors are being sued jointly and severally. But I've had cases where only the CEO was sued. We didn't join the other directors for strategic reasons, but it is possible that when that director is held liable, he can then commence either separate proceedings, or he can join other directors to the same proceedings. So that is possible, Colin. Yeah. I was then asked to talk about the litigation process. Now, litigation, of course, you can either have litigation in court under the rules of court, or you can have litigation by way of arbitration. And many contracts nowadays incorporate compulsory alternative dispute resolution mechanisms for resolving disputes. But if you are in court, then, it's a process that takes time. It is a process that requires intensive preparation with your insured. And it is an expensive process. So if you're a director and you get sued, it's a process that you can anticipate may take anywhere from 2 years to probably 5 years, if not longer, depending very much on when do you get a trial date, how long does it take eventually to get to a trial date if you go through all the processes. So it's a lengthy process, it's a detailed process, and it's very costly. And as I said earlier on, you are at the back of your mind always confronted with with the knowledge that interest is running at the legal rate in respect of this claim that's made against you. And that in and of itself becomes almost an incentive for trying to go to arbitration and see if you can get this dispute resolved quicker than to wait 2 years for a trial date. As I said, the current trial date, if you apply for a trial date now, in a civil matter, you probably will be allocated a trial date after February of 2027. And if you apply for 5 days, then you're probably looking at after July of 2027. So you can just do a calculation what interest will do to that claim by the time you get to court. And it's a factor that's constantly being overlooked. And if I can say anything about the management of civil litigation, is bear in mind what is the quickest process that I can follow in order to achieve a binding outcome, whether it is by way of a judgment, award, or a settlement. But you want to do it quicker and as quickly as possible.
And also to just ensure that memory is intact, right? I mean, you've got 5 years or 2 years of you trying to remember all the details, and yes, we have affidavits and evidence and discoveries and all of that, but to remember these things from the human brain is also taxing and challenging.
Hopefully you kept notes.
Hopefully you kept notes. So always keep notes. Always keep notes.
But if a witness tells me he can remember what he had for breakfast a month ago, then I just believe that witness. So talking about events as complex as they come in civil litigation, that happened a long time ago, is a difficult thing, and that's where preparation is so important.
Yeah.
Now, one must just in the timing of litigation always bear in mind that there's a possible appeal process on top of that. And the appeal process nowadays does not necessarily stop with the Supreme Court of Appeal, but it could go to the Constitutional Court. So making that process even longer, exposure to your cost, exposure to interest and all of that.
So, Donnie, I think you've had more experience in this regard. Like the personal impact on a director that let's say is subject to civil litigation must be immense, especially if it drags out over 10 plus years.
Yeah. There are a couple of things to say about that, because we don't always, I think, pay enough attention to that. The first is, it's the director's reputation that is at stake. He may ultimately be held not liable after 5 years, but in between all of that, he's on the front page of the Sunday Times so many times, or the company is there and so on. So there is an inherent disadvantage to even an innocent director, and his reputation is affected by it. I have seen directors go grey in the course of litigation. It is serious because you are being put under the spotlight. Your conduct 5 years ago is being critically analyzed from every angle, and it is a very uncomfortable and a very lonely place. And that's why you will want the best representation, and you will want an insurer that will back you through that process and partner with you right until the end. So we spoke earlier about that it is really difficult after the African Bank case to hold directors liable for their conduct, certainly in relation to claims by shareholders. But one should not, by that, forget that there is this section in the Companies Act called Section 165 that deals with derivative actions. And it is, again, one of those provisions of the Companies Act that is not generally known, and probably not enough attention is given to how far-reaching this provision is, because it creates a mechanism whereby, for example, a director or a shareholder or a union representing the employees can demand of the company to take action against a director. You know, they, particularly maybe years gone by, it was perceived that directors are almost like untouchable. And that, I think, must be balanced with a view that although Section 165 now, in its current form, has abolished common law derivative actions, there is still this mechanism that is available to force the company to take steps against a director. And again, we spoke about predictions and things that may come. And I think that Section 165 is going to be used more and more to achieve what people thought they could achieve in relation to, for example, claims by shareholders against directors.
So is this the mechanism shareholders would use to encourage the company to take action if they believe that there's been wrongdoing?
Correct. If the mechanism is created in order to put the company back in the position where the value lost by the shareholder is restored. Okay. But it's a mechanism forcing the company to take action against the directors. So it starts with the issuing of a demand by the people who are identified in Section 165, where it gives those limited number of people or anyone authorized by a court to issue a demand against the company to take certain steps to do things. For example, to issue a summons against a director. And the company is then obliged to respond in terms of the section. It has 15 days to either go to court to say that this demand is without merit, or it has to appoint a person or even a committee to investigate the merits of the demand that is made. So it sets in motion a whole train of things that will have to take place and that will, I promise you, be drawn out and extremely costly. That will ultimately allow a successful applicant to force the company to take actions. And once a person has been given the right to pursue an action like this, that action can only be terminated with the consent of the court. So don't think you can, on the side, go and do a deal. It has to be a deal that is approved by the court.
Yeah.
It is a very important mechanism in order to ensure that this provision actually functions and is seen through to its full consequences.
So even though it's not a trial running, the court still inserts itself into the process and the investigation and oversees the outcomes.
The court has the final say, yes. Yeah.
Very onerous.
Yeah.
So the important thing just to mention is, again, that it is it is a mechanism aimed at enabling the company to recover from the people who caused it to suffer loss and to therefore restore the position of the company. That's a very important point to just bear in mind. Just a few words about the common law position of derivative actions. It is recognized in our law, was recognized until the current version of the Companies Act came into operation, and Section 1651 especially then abolished the common law rights and said henceforth the provisions and the mechanism set out in that particular section will determine how derivative actions will function in this country under our law. Now, another provision that is very important when it comes to the way company directors can be penalized in a way is, of course, to hold them, to apply to court to have a director declared delinquent. That is normally somebody who grossly abused their position, somebody who took personal advantage of information, or someone who inflicted, through gross negligence, willful misconduct, or breach, harm upon the company. So it is a section of the Companies Act that is more and more being utilized, and it has far-reaching consequences. A director can be held to be delinquent and not able to take up a position as a director for life. So although there are ways in which the director can apply to court to reduce that period or to redeem the director, it is still a far-reaching consequence. Now, what are the things that keep directors awake at night?
Other than what we've mentioned.
Just mentioned, yeah.
Other than other than those small things we sort of touched on this morning, we do an annual survey, and the object of it is to determine what are the top risks perceived by directors in the finance and insurance industry. And in this year, they were cyber attacks, as probably anticipated, systems and control failures, data loss, big worry, health and safety, perhaps quite a strange sort of topic if you look at all the others, but health and safety is still a very topical thing. Regulatory breach, Colin and Pierre spoke about that earlier on. Bribery and corruption, and then breach of sanctions. So these are the top things that we are told are perceived by directors and officers as things that they are concerned about in the present climate. When we break it down into top risks for directors and officers in Africa, health and safety came up first. That's a very important distinction, and particularly in a country like ours where you've got mines and big industries and so on. So health and safety is a top concern. Breach of human rights, something that you didn't see on the global index. Breach of human rights, top concern for directors in Africa. Bribery and corruption, perhaps anticipated, I don't know, but certainly it's the third on the list. System and control failures, then insolvency and bankruptcy, also a concern. Supplier business practices feature there, and then data loss. Data loss, Colin and Pierre spoke about earlier on in the context also of cyber. Now, it's interesting that cyber is not specifically mentioned there, but I think you must accept that cyber is a top risk no matter where you are in the world, including locally. I am fortunately not a cyber lawyer, but if there is a worry that you should have, it's certainly a cyber breach.
Can I mention something? It's interesting that you say that. The D&O policy is certainly not an alternative to a cyber policy. It doesn't provide for incident response and all of that. But the D&O policy does cover some elements that are not typically covered by a cyber policy. So, for example, we saw in the CrowdStrike incident recently, there was a shareholder class action brought against the company for certain misrepresentations that they made about the security of the systems and the testing of the security services before they roll it out. And they also joined the CEO and the CFO to that, and it was a claim for $25 billion. So, I mean, that's not something that would be picked up by a cyber policy, even if you accept there was some ransomware or threat actors involved. But the D&O policy would. So it's a D&O policy also helps in the context of fiduciary breaches by directors.
Yeah, it is actually where, in terms of my expertise, certainly where the liability is profound. And that is whether or not the director has taken steps in order to put in place the systems and controls that would have prevented that data breach or certainly the loss of personal information, for example. So the liability of the director is for failing to have put in place
Policies,
systems that would have protected the company against it. And it's the company that, of course, is going to be sued, because we know from Section 19 of the Companies Act that a director or a shareholder is not personally liable for the debts of the company. It's the company that is liable, and therefore, if there is a loss suffered by third parties as a result of a data breach and so on, it's the company that's liable in the first place. But the company can look to the director and recover from the director the loss suffered by the company. So, it goes
It's a
goes the
circle.
whole
Yeah.
all back into where we started. Yeah, just a last comment on climate change and risks associated with those. We live in a country, and I think it's a good thing, that NGOs are very powerful. NGOs have money to force public interest issues. And they do so. You know of, for example, the case against Shell on the West Coast. There was also action that they tried to take against some of the banks. But where that liability is again important is, of course, the allegations of liability that are made. Those allegations are sufficient to trigger a right under the policy. And that's where the D&O policy comes in. It's not only for liability, but it's also for the allegations of misconduct that can and could give rise to that liability. I think that's me.
Thank you, Donnie. That was very, very insightful. We unfortunately only have time for probably one question that's been running through our chats, and I'll just hand it to the panel, but I'll start with you, Colin. Just in terms of being a director, it's not. For example, a person is not really on the company's letters and deemed as a director. Who would be deemed to be covered, or rather, who is a director? Just as a broad sort of question.
Yeah, that's not a straightforward answer. So, in terms of the Companies Act, if you're a director, you're appointed and you're accepting that appointment, as Donnie said to us earlier. But there are certain key responsibilities that may find you being liable in your personal capacity because of the role that you're fulfilling. And that's why the definition of director in terms of the policy is quite wide. That may include management or employees, depending. So it depends on the allegations that could make you liable as being a director. It doesn't mean that you necessarily have to be the one appointed and signed up at CPRC or wherever you register that. I don't know if you can add anything to that, Donnie.
Yeah, I mean, if you look at Section 77, for example, it specifically says, in this section, a director includes an alternative director, of course, that we know, but it also includes a prescribed officer or a person who's a member of a committee of the board. So it could be an employee who sits on the committee of the board. Yeah. So even if I don't have the title of a director, but I perform the functions of a director, then I would still be liable qua director, as a director.
Yeah, so plain and simple, that's exactly what we wanted to echo, is that you just don't need the title to do so. So the functions and the responsibility are there. So thank you. We've heard from the panel. I think it sums up to say that D&O is essential, critical, core, because it protects the personal assets. If any takeaways is to protect personal assets of directors while managing their company. I think also in a complex world that we have today, where there is claims from customers, creditors, regulators, and all in between, shareholders, I think being without this cover would not be the most advisable sort of decision to make. And also the constant fear of knowing that there could be legal sort of liability that's attached, and you can actually go and do your work, making the strategic decision making that as a director you adhere to. I think I want to leave you with this, but I want to thank firstly our esteemed panelists for today, for engaging such an informative discussion. your diverse perspective on certain regulators and aspects have been really insightful. And I want to leave you with, it wouldn't be me if I don't leave you with another quote, which is from JF Kennedy, and he says, "The time to repair the roof is when the sun is shining." So let's try and get our policies in place, get a reputable insurer. I hope that the session was informative and it gave you things to think about. And thank you all for listening in today and being part of today's sessions. Thank you all as well, and thank you to our listeners. Thank you.